The letter was sitting on the kitchen table when I got home from my walk. Not a bill, not a card. A sealed envelope with my son-in-law's name printed in the return address corner, the logo of a law firm underneath it, in small blue letters. My daughter was in the kitchen, back turned, stirring something on the stove that she didn't need to stir. She knew I'd seen it. I set my keys down the way I always do, on the hook by the door, and I waited. She turned around. Her face was arranged carefully, the way a person arranges their face when they've been rehearsing. She said, "Dad, we need to talk about the house." I said, "Okay." She said that her husband thought, and she'd agreed, that it made more sense for everyone if I moved to the assisted living place over on Millbrook Road. The one with the garden. She said it like that. The one with the garden. Like the garden was the point. I'm 63 years old. I cut my own firewood. I drive myself to the doctor. I walked 4 miles that morning on a trail I've been walking for 22 years, since her mother was still alive to walk it with me. I didn't say any of that. I asked her when this decision had been made. She said they'd been talking about it for a while. I asked how long a while was. She looked at the envelope and then looked back at me. "A few months," she said. "The thing about being blindsided is that it doesn't feel like being hit. It feels like the floor changing material under your feet when you weren't expecting it. One step it's hardwood, the next step it's something softer, less certain. I stood there on that softer ground and kept my breathing even. I told her I needed to read whatever was in that envelope. She said her husband had explained everything inside. I said I'd like to read it myself. She moved away from the stove, and I noticed then that her coat was already on, her purse already on her shoulder. She planned the length of this conversation. I sat down at the table and opened the envelope after she left. The letter was from a firm I didn't recognize. 2 attorneys listed at the top, the downtown address. The language was formal and dense and took 3 paragraphs to say something that could have been said in 1 sentence. My son-in-law was requesting that I vacate the property within 60 days, the house I'd owned for 31 years, the house where my daughter had grown up, where her mother had died in the bedroom at the end of the hall, where the height marks of both grandchildren were penciled on the doorframe of the pantry. The letter called it the property. It used that word 6 times. I read it twice. I set it flat on the table and smoothed the crease down the middle. I want to tell you something about that moment, because I think it matters. I wasn't angry in the way people expect anger to look. I didn't feel heat behind my eyes or the urge to call someone. I felt something quieter and colder and more useful than anger. I felt the particular clarity that comes when someone removes all ambiguity. There was no more wondering if things were fine. They weren't fine. And now I knew exactly what I was dealing with. I got up, poured myself a glass of water, drank half of it standing at the sink, and looked out at the backyard. The maple I planted the year my daughter was born was dropping leaves, big orange ones, the size of my open hand. I watched one fall the whole way down. Then I went to my office and started making calls. My son-in-law had come into our lives 11 years ago, when my daughter was 32. I'd liked him well enough at first. He was organized, well-spoken, the kind of man who always knew which exit to take on the highway. He had opinions about wine, and he stated them with a confidence that I found slightly amusing, and my wife had found charming. He worked in commercial real estate. That detail had not seemed important at the time. What I understood now, sitting in my office with the letter in front of me, was that the detail had always been important. The house was in my name. It had been in my name since I'd paid off the mortgage 9 years ago, the same week I retired from the county assessor's office after 34 years. The deed was mine, clean and uncomplicated. There was no legal mechanism by which a letter from his attorney could compel me to leave. but I'd spent enough time around property law to know that the goal wasn't always legality. Sometimes the goal was pressure. Sometimes the goal was to make a person feel small enough that they walk out on their own. He had misjudged the person he was dealing with. I called my attorney the next morning. Not a family lawyer, a property attorney I'd worked with years earlier on a boundary dispute with a neighbor, a man named Fletcher who was 68 years old and spoke like a judge and billed like a surgeon. He listened to the whole thing without interrupting me. When I finished, he said one sentence. "Send me the letter." I scanned it and emailed it before I hung up the phone. Fletcher called back that afternoon. He said the letter was a document of intention, not of authority. It had no legal standing. No court had been petitioned. No proceedings were pending. It was, in his words, a pressure tactic dressed in letterhead. I told him I knew that. He said good. He asked if I wanted to respond formally or let it sit. I told him I wanted to understand the full picture first. He told me to document everything. That evening, my daughter called. She was warmer than she'd been the day before, the rehearsed edge gone, something more uncertain in its place. She asked if I'd had time to read the letter. I said I had. She said that it wasn't meant to be cold, that they'd had a financial advisor look at the numbers, that the house was a large asset, sitting idle, and that the equity could help with my retirement in a way that simply living there couldn't. She used the phrase financial advisor twice. She said her husband felt strongly. I let her talk. I didn't interrupt and I didn't agree and I didn't argue. When she finished, I asked her one question. Did you know your name is on the deed? There was a pause on her end. A long one. I told her that when her mother died, we'd updated our estate documents together. Her mother had wanted her protected, regardless of what happened after. So we'd added her name as a co-owner, secondary to mine, effective upon my death or in the event of incapacitation. Her name was on that deed. It had been there for 7 years. And what that meant, legally, was that any attempt to compel me to sell or vacate would require her active participation. She was quiet for long enough that I could hear the television in the background on her end. I said I wasn't telling her this to start a fight. I was telling her because I wanted her to have the full picture before she made decisions based on someone else's version of the facts. She said she'd have to call me back. She didn't call back that night. The next morning, I drove to my county recorder's office and pulled a certified copy of the deed. Then I drove to Fletcher's office and we sat across from each other at his desk, and he walked me through what I already largely knew but needed confirmed in his voice by his expertise. The addition of my daughter's name created a shared ownership interest that couldn't be dissolved by a third party. Her husband had no standing in this property. He was not on the deed. He had never been on the deed. He had not contributed to the purchase, the mortgage, or the maintenance of the house for any of the 31 years I'd owned it. Fletcher looked at me over the top of his reading glasses and said, "Whoever drafted that letter either didn't do their homework or hoped you hadn't done yours." I thought about that on the drive home. By the third day, the pattern had started to clarify. My son-in-law had sent 2 more messages through my daughter, each one more insistent than the last, each one using slightly different language to apply the same pressure. The phrases changed. The intent didn't. He wanted me out, and he wanted the sale proceeds, and he had convinced himself that 60 days and a letterhead would accomplish that. I didn't respond to any of it. I documented everything. On the 4th morning, my daughter came by in person. She sat at the same kitchen table, and she looked tired in a way that had nothing to do with sleep. I made coffee and set a cup in front of her and sat down across from her. She asked me why I was making this difficult. I told her I wasn't making anything difficult. I was living in my house. She said her husband had already spoken to a realtor. The house could sell for between $410 and $440, depending on the market. That after fees and taxes, There would be enough left for me to be comfortable somewhere smaller. That Millbrook had waitlists, and she wanted to get my name on one before the good rooms were gone. I looked at Shale. I mean that I really looked at her the way you look at your child when you're trying to find the person you raised inside the adult they've become. She was 51 years old. She'd learned to ride a bike in this driveway. I'd driven her to the hospital the night she went into labor with her first child. I said, "Your name is on this deed." She already knew that. What I said next was the thing I'd been waiting to say clearly, without anger, so it would land as information rather than accusation. Any sale of this property requires your signature. And before you sign anything, I need you to read the document your mother and I had prepared. All of it. Not a summary from your husband. The actual document. She sat very still. I got up and went to the filing cabinet in my office. The folder was where it had always been, third drawer, behind the tax returns. I brought it back and set it in front of her and sat down. The document was 12 pages. I gave her the time she needed. She read it in 20 minutes. I refilled my coffee and looked out at the backyard and listened to the pages turn. When she finished, she set the last page down on top of the others and sat with her hands flat on the table. There was a condition in the estate plan that I hadn't mentioned on the phone, one that went beyond the deed. Her mother, who had spent 30 years as a paralegal before she got sick, had insisted on a specific provision. Any voluntary sale of the primary residence during my lifetime required either my willing and uncoerced consent in writing, documented separately from any sales contract, or a court determination that I lacked the capacity to make the decision myself. The provision had been drafted precisely because her mother had known what grief and age and isolation could do to a person. She had wanted me protected from strangers and from anyone who might not have my interest at heart, including, the language was careful but clear, family members acting under outside influence. My daughter looked up from the table. Her mother had known something. I couldn't say what exactly, but she had known enough to write that sentence. My daughter didn't say anything for a while. The refrigerator hummed. Somewhere outside, a car pulled out of a neighbor's driveway. She picked up her coffee cup, and it was empty, and she set it back down. She asked me why I hadn't told her about this sooner. I said I'd been hoping I wouldn't need to. She asked if her husband knew. I said that was a question worth asking him. She left an hour later with the folder. Not a copy. The original. I made a scanned copy for myself first and emailed it to Fletcher before she walked out the door. But I let her take the original because I wanted it in her hands. I wanted her sitting with it in her own house that night, reading it again without her husband summarizing it for her. The call started the next morning, not from my daughter. From him. He called my cell twice before 9. I didn't answer. He left a voicemail the second time, his voice measured and professional, the tone of a man accustomed to negotiating. He said he thought we'd gotten off on the wrong foot, and he'd like to meet in person to talk through the options. He used the word options 4 times in 90 seconds, which is a commercial real estate habit, using the language of choice when what you mean is pressure. I texted back one sentence. Please direct all communication to my attorney. He called again at 11. I let it go to voicemail. He said he didn't think attorneys needed to be involved in a family matter. He said that involving attorneys made things adversarial, and he wanted to keep things civil. I saved the message and forwarded it to Fletcher with a note. He replied within the hour. Good, keep collecting. By early afternoon, a mutual acquaintance, a man from our church who I'd known for 20 years, called to mention that my son-in-law had spoken to him, that there was some concern about my ability to manage the house on my own, that perhaps people were worried about me. I thanked him for letting me know, and I asked him if my son-in-law had used the word capacity in the conversation. He paused. He said something like that had come up. I hung up, sat very still for a moment, and understood what the next move was going to be. He was going to try to establish that I wasn't capable of making my own decisions. I called Fletcher. I told him. He didn't seem surprised. He told me to make an appointment with my primary care physician. Not because anything was wrong, because documentation is armor, and I needed to put mine on before someone started swinging at it. I called the doctor's office that afternoon and got an appointment for 2 days out. In the meantime, my daughter called that evening. Her voice had changed, not the tired, managed tone of our last conversation. Something rawer, less certain. She said she'd read the document again. She said she didn't know about the provision, that her husband had told her the estate plan was straightforward, that there was nothing complicated about it. I asked her when she had last spoken with an estate attorney of her own. She said she hadn't. She trusted that her husband had looked into it. I said gently that was worth thinking about. She was quiet for a long time. Then she said she needed some time. I told her to take it. The doctor's appointment went the way I expected. Dr. Anand had been my physician for 14 years. He knew my history, my numbers, my habits. He asked me straightforward questions, and I answered them straightforwardly, and at the end of the appointment, he provided a written summary, clinical language, no ambiguity, that described me as cognitively intact, physically healthy for my age, and fully capable of managing my own financial and personal affairs. I asked him to date it and sign it, and have it notarized through the office. He looked at me over the edge of his clipboard and said he hadn't had a patient make that specific request before. I told him I hoped he'd understand why I was making it. He said he did, and he did it. I handed the document to Fletcher that afternoon, and he added it to the file. That evening, the letter arrived from my son-in-law's attorney. Not the same attorney as the first letter, a different firm, smaller, the kind that handles guardianship proceedings. The letter didn't initiate anything. It made inquiries. It expressed concerns. It floated the possibility of a welfare check, all in language careful enough to walk back. But the direction it was pointing was unmistakable. Fletcher called me after I forwarded it. He said 2 things. 1, this is an escalation. 2, they made a mistake, escalating, because now we can respond formally in a way we couldn't to a pressure letter. He began drafting a response that evening. What happened over the next week happened in writing, which is the way things should happen when they matter. Fletcher sent a letter to both firms with the deed, the estate document, the medical certification, and a chronological list of contact attempts and their dates and contents. The letter stated that I was cognitively intact, legally protected, and represented by counsel, and that any further contact outside of appropriate legal channels would be documented and addressed accordingly. The response from the first firm came in 3 days. The guardianship inquiry was withdrawn. The language was careful, professional, and final. My daughter called the same day the letter arrived. She said she'd gotten a copy from her husband, who had been shown it by his attorney. I could tell from the way she said his attorney that something had shifted in how those 2 words felt in her mouth. She asked if we could meet. I said yes. She came on a Saturday morning. She didn't bring her coat this time. She sat down and she said she'd had her own conversation with her own attorney, a woman she'd found herself, and that there were things she hadn't understood about the estate documents that she now understood. She said her husband had told her the plan was simple. Her attorney had told her it was not simple, and that the provisions her mother had included were unusual and specifically protective, and had clearly been drafted by someone who knew what they were doing. I told her that her mother had known exactly what she was doing. She looked at the table. She said she was sorry. Not sorry in the way people say it when they mean I got caught. Sorry in the way my daughter had always apologized when she was a child, quietly, without qualification, taking the full weight of it. I recognized it. I told her there was nothing between us that needed fixing, that what needed addressing was between her and her husband, that I wasn't going to tell her what to do with her marriage, but that I wanted her to make decisions with full information, not pieces of a picture someone else had assembled for her. She stayed for 2 hours. We talked about her mother. We talked about the grandchildren, both of them in high school now, one of them already looking at colleges. We talked about small things, the maple in the backyard, the height marks in the pantry, whether I should repaint the kitchen before winter. She looked at the marks on the doorframe when she left. She stood there for a moment with her hand touching the wood above the highest pencil line. Her son's. He was 15 when we made that mark. He's 17 now. She left without saying anything else about it, and I understood that she didn't need to. The formal proceedings ended the way most paper processes end, not with a moment or a confrontation, but with a series of confirmations. The guardianship inquiry was officially closed. The original letter from the first firm was rescinded in writing. Fletcher received acknowledgement from both attorneys that the property was not subject to any sale, voluntary or otherwise, absent my documented and willing consent. My son-in-law stopped calling. I don't know what was said in his house. I don't know what he told himself about how the situation had resolved. I know that his name never had any claim over this house, and that whatever story he'd been telling himself about what he could do had simply collided with what the paperwork actually said. 3 weeks after the last letter arrived, I was in the backyard raking leaves when my grandson came by on his bike, unannounced, the way teenagers sometimes do when they need somewhere to be without having to explain why. He helped me rake for an hour without asking any questions and without me offering any explanations. We filled 4 bags. He drank a glass of water at the kitchen sink and looked at the height marks in the pantry and pointed to his own and said that seemed wrong, that he was definitely taller than that now. I told him to stand flat against the doorframe. He was 2 inches taller. We made a new mark. I wrote his name and the date beside it, the way I'd done since he was old enough to stand on his own. He left on his bike the same way he'd arrived. I watched him go down the driveway, turned back to the yard, and looked at the maple. 31 years. Some things you earn with money, and some things you earn with time, and some things you earn by refusing to be pushed out the door. I wasn't angry anymore. I'm not sure I ever was, not in the way that burns. What I felt standing there in the cold with the rake in my hands and the leaves piling up the way they always do every October was something simpler. I was home. I had stayed. The house was still mine, and the mark on the door frame was fresh, and I had somewhere to be in the morning. That was enough. It had always been enough. The maple is still out there. Same tree, same yard, same October light coming through the kitchen window in the morning. Nothing about the house changed after all of it. That's the part that stays with me. When my son-in-law sent that letter, he was betting on something specific. He was betting that 63 looks like 63 in the way people assume it does. That a man who's lived alone since his wife died, who walks the same trail every morning and keeps his files in order and knows exactly where his deed is, can be nudged toward the door with the right combination of legal language and family pressure. He miscalculated. Not because I was lucky, because for 31 years I had done the unglamorous work of knowing where I stood. I think about that a lot now. My wife spent 3 decades as a paralegal. She sat in rooms where people lost things they should have kept, not because the law failed them, but because they hadn't paid attention to it when it was still on their side. She drafted that provision in our estate plan, not out of fear, but out of clarity. She understood that the people most likely to hurt you aren't strangers. They're the ones who decided their convenience matters more than your dignity. She wrote protection into a document because she believed that doing right by the people you love sometimes means doing the hard, careful, unromantic work of preparing for the worst. That's what integrity looks like when it's not performing for anyone. I didn't respond to my son-in-law's letter with anger, because anger would have been the wrong tool. What the situation required was something steadier. It required me to know more than he assumed I knew, to have already done what he assumed I hadn't done, to be 3 steps ahead, not because I'd anticipated him specifically, but because I'd spent a lifetime believing that understanding your own situation is not optional. You don't get to hand that job to someone else and hope they do it honestly. You read the document yourself. You keep the folder. You know the attorney's number. That kind of knowledge doesn't feel like power in the ordinary moments. It only reveals itself when someone tests it, and the staying part. I think that matters as much as anything else. There were moments in those days when the easier thing would have been to let the noise win, to tell myself it was just a house, that the grandchildren would still visit wherever I landed, that fighting a family member through attorneys wasn't worth what it cost. I understand why people make that choice. But I also know what I would have given up. Not just the house, the marks on the doorframe. The maple my daughter chose from a nursery catalog when she was 7 years old, the trail her mother and I walked every season until we couldn't anymore. Some things, once surrendered, don't come back in any form that resembles what they were. You have to decide they're worth the discomfort of standing firm. My grandson came back a week after we made that new mark on the doorframe. He didn't mention anything about what had happened. He just showed up, helped with the leaves, drank a glass of water at the sink. 17 years old and already carrying some instinct that some places are worth returning to. I don't know where he learned that, but I know this house is part of the answer. What I want anyone listening to take from this is plain. Do the quiet work before you need it. Know what's yours and why and how. Treat the people around you honestly enough that when the hard moment comes, the record speaks for itself. And when someone tries to make you feel small with paper and pressure and the assumption that you're too tired to push back, remember that patience and preparation and the refusal to be rushed are not passive qualities. They are the most active choices a person can make. The house is still mine. The tree is still there. The mark is still fresh. That's the whole story.